Hi, I'm criminal defense attorney Ryan Pacyga, and today I'm going to talk about what's called a federal 11C1C plea agreement. And that is that in federal court, typically speaking, if a defendant decides to work out an agreement with the government and plead guilty, they'll do a normal Rule 11 plea or Rule 11B plea. And that means that the prosecution and defense agree to have the defendant plead to one or several counts in an indictment. In exchange, the government may dismiss other counts in the indictment, and that the parties might agree or not that certain aggravating factors will apply or not, and that they'll guess at what a guideline range might come in at. The problem with pleas like that, and those are the most common, by the way, is that it doesn't bind the federal judge at all. And so the federal judge will look at a guideline calculation to begin their analysis of where the sentence ought to be, but then they can depart upward or downward, and it's fairly easy for them to do that because the guidelines are only advisory. And so once in a while, you want an 11C1C plea agreement, especially if you're the defendant, and that is because if you have particularly ugly facts and you're worried that a judge might want to give you more time than what the guidelines call for, or a higher end of the guidelines sort of sentence, then you want that predictability that you're going to get no more time than whatever you and the prosecution agree to, and so you can basically cap it off at a certain number of years or months. And again, you got to be careful what you ask for, because many times we're able to get sentences, most of the time actually, that are below the guideline range. But once in a while, the particular facts of a case are really bad, or the defendant's criminal history is so bad that we're worried that a particular federal judge might want to sentence them beyond even what the prosecution might think would be a reasonable sentence. And for that reason, that's one good reason to lock in an 11C1C. You don't automatically get to do those. That is that rarely the government will agree to them, but once in a while they will agree, and I've had the government agree to it before. But that's only part of it. The other part of it is that the federal judge has to agree to an 11C1C. One trick to watch out for is that the initial language in an 11C1C plea agreement might say that it binds the government or the particular prosecution office in the district that your client's being or the defendant is being prosecuted in, but that it doesn't bind the judge necessarily. Well, that really takes out all of the effect of an 11C1C and the purpose of it. The rule itself specifically says that if a judge accepts an 11C1C plea agreement, then they are bound to sentence according to what the number is in the agreement, the number of months or the number of years. So you have to not only have the prosecution agree to an 11C1C, but then the judge, and that can be tough. Most judges will not agree to an 11C1C right at the change of plea hearing itself. So after you reach a plea agreement with the government, you have to go into court and enter into a change of plea hearing, and at that hearing, the judge will make sure that the defendant knows their rights, that they're giving up their trial rights, all of the constitutional protections that come with a criminal case, and that there's really no taking it back once the judge accepts it. But most judges want to see what's called the pre-sentence report, or PSR, before they commit to accepting an 11C1C plea. And so what they want to make sure is that they've got a good handle on the defendant's criminal history, a good handle on the relevant facts in the case and the allegations, and any other information that they think would be necessary to make a determination that an 11C1C plea is fair. Because, for example, if someone's agreeing to a 5 or 10 year sentence and the judge finds out that there's a whole lot of bad history about a defendant, or there are really particular bad facts, the judge might say, this is too light, I don't approve of it, and then the defendant is able to undo their plea and continue proceeding on towards a trial. And sometimes the parties can rework another agreement or another 11C1C, or come to other agreements in the case, maybe dismissing other counts or things like that. So it doesn't mean that automatically a case has to go to trial if the judge doesn't accept an 11C1C, but obviously it's not the ideal situation. So a couple ways to help get a judge to accept an 11C1C agreement obviously is first that the defendant behaves that during the time that they're either in custody awaiting a change of plea hearing and then awaiting sentencing, or if they're out of custody, that they're behaving as well and complying with all conditions of pretrial release. If you pick up a new charge or any other offensive behavior that violates pretrial release, or you get in trouble while you're in custody, either by getting in fights or the like, you could really undo your chances of getting an 11C1C accepted by the judge when you return for a sentencing hearing, which is after the PSR comes back. So after the change of plea hearing in 11C1C, then the defendant will have to go through a pre-sentence review, and that means meeting with U.S. probation, and the defendant's attorney should attend that meeting with them to make sure that nothing goes awry during that meeting with U.S. probation when they begin to prepare the pre-sentence report. And that can be a lengthy process. Each district is different. And then after that, the defense has an opportunity to object or disagree with any of the findings of the pre-sentence report, the initial report, and if so, they need to let the probation officer know that wrote the report, and potentially the court as well. Probation sometimes will fix the report if they agree that it's an error. Other times, there needs to be a dispute heard by the judge as to whether certain factors apply or not, or an evidentiary hearing can even happen or not. But at any rate, eventually you come back for sentencing, and then usually at that time, the judge, after having the benefit of reviewing the pre-sentence report, will determine whether or not they're going to accept an 11C1C agreement. If they do, then they're bound to, once they accept it, they're bound to give that defendant the number of months or years that were agreed upon in the 11C1C plea agreement. If not, like I said, you go back to the drawing board, and you can either go forward to trial at that point or try to seek another plea agreement with the prosecution. If you have more questions, I'm federal criminal defense attorney Ryan Pacyga. I'm based in Minneapolis, but I travel around the nation defending criminal cases. You can find me at arrestedminnesota.com or at 612-339-5844.